Let's get right at it. I'm going to introduce Gregg Zoeller, the Attorney General of Indiana.
Well, thank you, and thanks again to our host, the two newspapers of the area. You know, I grew up in a time back when I worked for Senator Quayle when almost every city still had two newspapers. So it's refreshing to see that Fort Wayne still has two newspapers that you can have one in the morning and one in the afternoon. And I appreciate the fact that they've still got a lot of interest in the media here. I also want to thank our other co-hosts here, the Hoosier State Press Association, and our friend in state government, the Public Access Counselor. This is the sixth, make sure I get this right, the sixth of 8 of these programs we're having all around the state. We've had very good turnout in almost every place we've been, and I think it recognizes a certain interest in the public in how their government operates. I tell everybody that our country was founded on the principle of not trusting your government, and it's served us well. So we're not here to tell you to trust the government. In fact, we're here to encourage people to know about their government, to challenge the government, and to really make sure that people in government are open and accessible to the people that we serve. First, let me start off with a little bit of the history. The Public Access Counselor's Office originally was in the Office of the Attorney General. In fact, a number of my colleagues, attorneys general in other states, still have the work that we see as the Public Access Counselor's job housed within the Office of the Attorney General. So up until 1998, the work done by the Public Access Counselor was in the advisory section of the Office of the Attorney General, which really puts my office and the work we do representing state government and providing opinions as part of the history of this work. The very first Public Access Counselor was the head of the advisory section of the Office of the Attorney General, Ann O'Connor, who's now back in the Office of the Attorney General in the advisory section. So we've got a history and a current role, but it's different than it was before 1998. The two things that I usually point out that is a continuing policy of the Office of the Attorney General to support the statutory interest of our legislation in open access to the records as well as the decision-making process of our government. The first policy is that the Office of the Attorney General will never second-guess an opinion of the Public Access Counselor. So we refuse to opine if someone asks for our opinion. We say that that's the only role of the Public Access Counselor, and we will never second-guess an opinion. So we fully support every opinion of the Public Access Counselor as it relates to at least all of our clients in state government. The second policy is that in the event that the Public Access Counselor tells one of my clients, the agencies within state government, that they're required to produce information for the public or news media, that my office, as a policy, will not defend the agency in a challenge. So the respect for the opinions of the Public Access Counselor, I think, stand for the proposition that they represent the state government's legal opinion, and that as a client, all of my clients are required to follow those opinions. And now you can imagine that that's not always well received by some of the agency heads and attorneys that are our clients, but I do think that it's the right policy and something that as long as I'm Attorney General is going to be the case. But after the history, we talk a little about really the basis, the reasons that we have the two statutes, the Open Door Act and the Access to Public Records Act. The principle behind this is to create transparency in government that'll be open to public scrutiny, And it shows that it's an important state policy to have accessibility and transparency to the people that are governed. So I think our laws are meant to allow citizens to not only have access to the information, but to see the process by which government decisions are made. Now, I started off, my first principle is that we're not here to tell you to trust the government. That's not part of our history, and it's actually not healthy. But all that said, that there's not supposed to be trust, complete trust in government, it's also required that these two statutes help government build at least a thread of trust between the government and the governed. And these statutes are our opportunity as government officials to try to maintain that thin thread of trust that I think is required between government and the governed. So it's not total trust. You're always supposed to be, let's say, healthy skepticism. Not paranoia, but at least healthy skepticism. But I think every time the government has an opportunity to be open and transparent, the more we have an opportunity to develop that thin thread of trust that's required. One of the things I think in the future that I'm hopeful will be built into our government systems is as we have technology advancement where we build out a platform of our computer systems that the information that is publicly accessible should be accessible without asking your government. We'll soon have the technological ability to put it online so that when people have questions, they should be able to refer online to the access to the information that they seek. In my office, we've done that for years with contracts, particularly with outside counsel, where we hire lawyers to be local counsel. How do we come about hiring them? How much do they get paid? All of that, when people say, I'd like that information, I'm proud to tell them it's online. Go to our website. We put as much information. Now, we do screen things like Social Security numbers and the things that we're required to, but I think in the future I'd like to see all of our information technology built on a platform that requires as much publicly accessible information as people have the right to know. The other part is to make sure that we continue to maintain the access of the public watchdogs, the media, that are under financial pressures, but we need to make sure that they have as much access to the information so that the voice of the watchdog, the media, can continue. I don't know if I've used this analogy, but the watchdog, they're supposed to bark when government does something wrong. And they need to have access to the information so that they can continue to provide a challenge to government to always do better. The other part that I throw in as part of something that I personally have tried to follow is that sometimes government needs to admit that they make mistakes. And it's hard, I'll tell you, it's hard as an elected official to stand up and say you've made mistakes. But everybody in the public knows if you never admit to a mistake, they all assume that you've just covered it up because you're clearly going to make mistakes in the past. So I do think that even by coming forward and telling people that you've made a mistake, that you can help build more trust, not a lot, but a little trust by just saying, hey, look, we didn't do this right, and we'll do better. So I think the example that I've used in a couple of other places is a case we had against a veterinarian in Brown County. Now, this veterinarian refused to answer information when my attorneys asked because there'd been some consumer complaints. Well, after the third time of asking and not getting any information, my attorneys, good attorneys, very aggressive attorneys, they do what they do to get your attention, they sue. Well, they bring the doctor, the veterinarian, before the veterinarian board by filing the action, only to find out that in Brown County, this local vet is considered the patron saint of all pets. And we were bombarded with all of the people who had brought their animals to this specific vet, who, again, everybody loves in Brown County. Now, the reason that he hadn't responded was because he was working day and night with animals that were lined up waiting to come in to see him. So, recognizing that we had sued the Albert Schweitzer of the animal kingdom, I was on a drive with my children down to Brown County to one of the camps, and there's this line of people in the parking lot with their animals waiting to get in to see the vet, the sainted vet. So I went in, I stopped and went in, and I said, I don't want to bother him, I know he's busy, but just tell him, that I came by, and I wrote him a little note. She said, oh no, I recognize you, and I'll stop and see if he won't come out. So he came out, and I said I was sorry that if I've caused any real pain, and he said, well, I understand you have to do a job, and it's, but I do think it's appropriate that when you say, I wish it hadn't happened, I wish we had done a little more homework, I wish we had, let's say, more fully looked at the problem. So you have to admit, I can do better, and I promise that I'll do better in the future. I called, I think, the local media, the Brown County Democrat as the local media down there, and I said, I stopped by and apologized, and I made a mistake. But it's that kind of willingness to just say, we've got a lot of work to do, and there's a lot of things in government that if people can show me that I've done things poorly or that I could do it better, I appreciate people coming forward and challenging me to always try to do better, and if I've made a mistake, I'll try to own up to it. And again, I promise to at least continue to make the effort to develop and maintain some thin thread of trust. And that's, I think, the opportunity that we have with these public records questions and the open access with the Open Door Act. So with those few words, let me kick it off to our state's first public access counselor and one of the deputies in my office, Ann O'Connor.
Thank you, General Zoeller. And can everybody hear me? I get accused of not being loud enough. My children would disagree with that. My name is Ann O'Connor, and as the Attorney General mentioned, I was the first public access counselor back in the late 90s. And sitting to my left is Andrew Kossack. He is the current public access counselor, so anytime you contact the office now, Andrew is serving in that position. And to my right is Steve. Steve Key, who is the Executive Director and General Counsel for the Hoosier State Press Association.
We can't hear
I know. Can you hear me now?
Yes.
Steve Key is the Executive Director and General Counsel for the Hoosier State Press Association. As the Attorney General also mentioned, this is the 6th of these that we are doing, and we're getting pretty good at it, but we notice too that sometimes your questions may be different than the things we may address, and so as we're progressing through our presentation, feel free to raise your hand if you have a question, especially if it's sometimes even more relevant if people hear it in the context of when we're talking about that subject matter. So feel free to raise your hand and we'll try to recognize you and answer your questions. Now, a couple of housekeeping things before we get started. In your materials, I think everyone should have gotten a booklet. There's a stack of them back there. This is as of 2008, but in your package, your folders, there's also a 10-page addendum that has all of the statutory changes. We will incorporate this all into one book, and the book is actually available online as well. Look at the back at the website for the Public Access Counselor. And it's actually a pretty good tool because if you go onto the electronic version, if you're just searching for a term or a topic, it's searchable. So not that the handbook isn't great, we all love the handbook, but just wanted to point that out. Also in your packets, there is a survey that, it does say continuing legal education survey, but even if you're not here as an attorney getting CLE, please fill this out for us because it helps us to prepare for our later presentations, and if you are an attorney seeking CLE, if you're staying for the entire 2 hours, you need not do anything with the other side, but if you have to leave early, complete this form and get partial credit. Okay, so we're going to get started. The way we've been doing this, we'll start with the Access to Public Records Act, and then we'll follow up with the Open Door Law. So I'm going to ask Steve to get us started on Public Records Act.
First off, I want to congratulate everyone for taking the time and the interest to come out. This is a great crowd. I know seats I think are filling up.
There's a couple here.
There are 2 or 3 in the front, so nobody should have to stand, hopefully. But I think it's just a great testament to the community that you got this many people who want to turn out, whether they're attorneys looking for CLE or they're
Getting direction from
she's
the
getting
back.
stage direction. Whether or not it's attorneys looking for CLE, or if it's public officials who want to better be able to meet their obligations to help the public get information, or just citizens who want to know what the law is. I think it's just terrific that there's this big a crowd here in Fort Wayne. And I think that's kudos to the community. We want to start off with the Access to Public Records Act and talking about the philosophy, what the General Assembly was trying to do with this. And what they base it on a premise I think that we can all agree on, and that is that government serves the people. It's not like the monarchies where the people serve the king, but our public officials serve the citizens. And because of that, the legislature found that all persons are entitled to full and complete information about the affairs of government and the official acts of those who represent them. So it puts the onus on the government to make information available. And a key part of this that sometimes public officials will forget is that they specifically stated in the statute that providing information is an integral part of the routine duties of public officials and employees. Occasionally you'll hear about a public official who kind of takes offense that they're going to have to take so much time and effort to try to answer citizens' requests for information. But the General Assembly very clearly said, hey, that's just part of the regular job, just along with everything else that you do. And so we always urge and remind the public officials and employees that this is just part of the job. It's not an extra burden, but it just should be a routine part of the job. The other thing that I find, and this is more for the attorneys, is on occasion the attorney representing a public agency will be approached by the school board president or the council, and they say, man, we've got a really hot topic, and it's going to be, could be embarrassing. You know, is there a way we can do this behind closed doors? There's this record that we don't have to give someone. And again, the legislature specifically in the first part of the statute said that the Access to Public Records Act is to be liberally construed to implement the policy of providing information. So often what happens is the attorney goes back to the section on the exceptions, and they say, you know, I think this document we can try to push and stretch and fit into this pigeonhole and declare it confidential. And then they'll end up, if they get challenged in court, and the court will immediately go to the initial provision and say, no, this is to be liberally construed, which means the exceptions are to be narrow. And sometimes the attorneys forget to go to section 1 and they go straight to the exception. So remember, everything is geared towards access and limiting secrecy as much as possible.
Well, following on with that, the General Assembly also provided in the statute that the burden is on the public agency as a general rule to show that a public record is not disclosable, not on the person making the request. There are a few exceptions, and they're very specific by statute, but I think this is also a good time to sort of do an overview of public records. And public records are those of a public agency, but there are 3 categories that statute lays out. One would be confidential public records. These are records of a public agency that they cannot disclose unless a court orders disclosure or there's another statute, federal or state statute, that says in a certain circumstance they can disclose it. Those would be things, certain birth information and other types of records that you cannot, unless it happens to be about you, times. For the most part, they're not going to give it to anyone. Income tax returns, for example. There are also several categories, I think we counted there's 23 maybe, categories of discretionarily disclosable public records. And those are categories of records that the General Assembly has recognized that a public agency has discretion, which means they may withhold information that falls into those categories. Again, the burden's on the public agency to show that is an appropriate exception. One example that comes up a lot is deliberative material, which we'll talk about later in more detail, and then investigatory records of a law enforcement agency. I think on both of these, those happen to be ones where people, as Steve mentioned, try to stretch, especially since deliberative, when we get to that definition, you'll realize it's probably the catch-all if somebody was looking for the catch-all. And investigatory records, a lot of agencies that are not law enforcement try to rely upon that, and it's very specific, an exception to the rule of disclosure, that it's for law enforcement agencies only. So, a lot of agencies do investigations, but they don't necessarily have the ability to rely on that exception. As I mentioned before, the burden lies with the public agency. So if someone comes and makes a request, generally, they don't have to show they have a right to get the record. The public agency, if the information they've requested falls into one of these categories, the third category, obviously open disclosure, sorry, open to disclosure. But if it's not one of the discretionary categories or confidential, then they should receive the information. But not only is there the burden to actually tell the person you can't have this record, you also have to tell them why. While the person coming in doesn't have to tell you why they want a record, it's not required under the statute as a general rule. You as a public agency, those of you who work in public agencies, if you're relying upon one of these exceptions, you have to state the statute. That is the basis. So it's not just a matter of, oh, we can't give that to you, it's confidential, sorry. You have to be more specific about your non-disclosure. And when I say that generally a person's purpose in getting the record is not important, there are times where the General Assembly has said, you may need to state a purpose. For example, when they changed the access to motor vehicle records a couple of years ago, there is a process by which people can get certain information from driver's license records, but you have to state your purpose. Many times it's for employers that are checking the driving history, especially for someone who might be driving one of their vehicles. But you have to, even if you do it online, you have to attest that that is the reason you're seeking the record. So those are things to keep in mind as both a requester and as a public agency.
Well, good morning, everyone. Thank you again for coming. This is a great crowd. I'm Andrew Kossack, Public Access Counselor, the fifth one. Big shoes to follow in Ann's, but happy to be with you. I'm kind of curious about what brings all of you here today. Like I said, it's a great crowd. So if you indulge me in a brief show of hands survey, it's going to be an oversimplification to make this division, but primarily there are people here because you're on the receiving end of public records requests, or you're trying to comply with open door law. Maybe you're on a board or a commission yourself, or you are an attorney who represents governmental entities in your daily work. Or on the other hand, you could be an interested citizen, a member of the media, or someone else for who, for whatever reason is submitting records requests or wanting to attend public meetings. So if you're on the receiving end of public records requests or on the compliance end of the open door law, could you raise your hand? Okay, thank you. And then if you're on the other side where you're submitting requests, raise your hand. Okay. And if you're just here for free CLE. All right. Thank you for being honest. I've done it myself. It's okay. And there's coffee over there if you start getting drowsy. First thing I wanted to talk about is something that both of those groups are going to have to deal with pretty early in the public records request process, and that's a phrase in the statute called reasonable particularity. When you're submitting a records request, there are pretty much only two requirements for that request, two reasons a government agency could say this is an invalid request. The statute says that records requests must be submitted with reasonable particularity, identifying the records that you're seeking. And then second, if the agency requires or asks you to submit the request in writing, or if they have a standard form that they use for requests, they can ask that you make that request either in writing or on their form. And if they have a form, they should respond to you and say, here's our form, please, complete it, rather than just ignoring your request. But on the reasonable particularity end, when you're a requester, you want to try to identify the records that you're seeking. I know that's not always easy because you don't know necessarily what they're named or how they're stored or categorized. So do the best you can to identify what you're looking for, and hopefully the agency will work with you to narrow that request. If you're on the agency side and you receive a request and you're not sure what they're seeking, the appropriate course of action is to respond back and say, we've received your request, it's not really clear what you want, we want to comply, but could you be more specific about what you're looking for? Unfortunately, there's no definition of this reasonable particularity phrase. It's been kind of hashed out in some of our advisory opinions since Ann's time and in between. So some general standards that you can kind of think about as you're on either side thinking about this issue. Is it a request that is particular, reasonably particular, or is it universal? And by universal, I mean requests like all of your agency's emails or all of your agency's faxes for the last year. That's a universal category of records. It's not a specific record. And, those universal categories are often filtered out and sent to different employees or different portions of the agency. So it's hard to comply with a request like that, even if an agency wanted to. And then secondly, can the agency discern what the requester is looking for? One example I used last week was I saw a request where a requester was seeking all scandalous emails sent among an agency for the last several months or something like that. So scandalous is kind of a tough standard to comply with. But if you narrow it and you say, I want all emails between these two people for these 2 months, that's much more narrow and much more easy to comply with. And then the last thing I'd say on it is, particularly if you're on the agency side, you may have a request where thousands of documents are responsive to the request. And that doesn't necessarily mean that it's not a reasonably particular request. It just means that there are a lot of responsive documents. So if you get a request like that, you can always go back to the requester and say, we've got 10,000 documents that are responsive to this. We can set up a time for you to come in and look through and find what you want. Or if there's some confidential information in portions of those records, and you can say, look, it's going to take us 6 months or whatever it is to sort through this. Can you narrow it down, and we can get you something much more quickly. Hopefully you can come to a good meeting point with the requester in that way.
Kind of following up on the request, the common mistake that I see that citizens or reporters make when they're trying to get information is they have a feel for what they want to try to find out, but what the mistake they make is that they ask basically a question instead of a request for documents. They'll say, well, how, instead of asking for documents or contracts, they'll ask for like how many people have contracted with the city for such and such a service. So they end up asking a question instead of asking for documents. So when you are making a records request, make sure you kind of review it and make sure that you are asking for records and not just trying to ask a general question. Because that way, if you're asking for a particular record, now the records, the question could be one that encompasses what you're trying to find out. I'm seeking all documents pertaining to records of contracts between vendors who provide materials for the county Department of Transportation for building of roads. So you can try to do your question, but make sure you're asking for documents and not just asking a question, because what you may do is you may give that public access or that public official who really doesn't want to bother with your request an easy out to say you're not asking for anything that we can respond to because it's just a question. So ask for records, not just a question. I want to talk about what is a public record. And the General Assembly couldn't have made the definition really any more broad, I think. I mean, it talks about writings, papers, reports, studies, maps, photographs, tape recordings. It talks about things I'm not even sure exist anymore, magnetic or machine-readable media. I'm not sure exactly what that is. But they're also looking into the future. You know, they said, you know, electronically stored data or any other material regardless of form or characteristic. So it's a very, very broad definition of what a record is. It's going to encompass email. It's going to encompass cookie files on a computer. It's going to encompass a whole lot of things. And as Ann was pointing out, the presumption is those documents or records are available to the public unless there's a statutory basis not to make them available. Yes?
Yeah, the question is, what about a wholly owned subsidiary of the city of Fort Wayne, for instance, city utilities?
Well, if it's it's a municipal utility.
Yes, it is. It's owned
Well,
by the
then
city.
it still falls under the Access to Public Records Act. Now, there are certain records that are specifically confidential concerning the customer's information, but other than unless there's specific exceptions or the documents fall under other general categories allowed to be confidential, the utility is subject to the Access to Public Records Act.
Can I be specific?
Sure.
On everybody's city utilities bill, there's something called a stormwater fee. And if you're a resident, it's a flat $3.65. But if you have commercial property, somebody sits up there and says, you pay this much, you pay this much, and you pay this much. And I wanted access to those records and was just flatly denied.
Did they give you a basis for the denial?
They cited some statute, and I should have brought my paperwork with me. I've had like 2 or 3 letters back and forth to the city attorney's office.
Yeah, my initial reaction would have been I would think that information would be available so that citizens can protect themselves and be able to say, hey, you've given me fee X, but I know I'm the same as this guy over here, and his fee is twice as much. But if they decide a specific statute, you know, I'd want to know what that statute is to see whether or not they may have a legitimate basis, or maybe something that, again, they may be trying to stretch. So, you know,
Should that
you may
be in
want
the
to.
handout you gave me?
What would be?
Should that be in one of these documents?
Well, I don't know what the statute is they cited, but obviously if you want to get with Andrew or Ann or I afterwards, and we can exchange information, and you can find that specific code that they were using.
Mm-hmm.
It might be one that's in the booklet, and we could be able to say, well, that's kind of a stretch, or if it may be located somewhere else in the code. There are a lot of places throughout the Indiana code that say specific documents are confidential. The Access to Public Records Act is more of a general, here's the general framework and general categories, but you may have a specific statute somewhere else in another part of the code that may specifically address your request. And so we need to know what code they were using.
And a lot of times those are just based on volume, some sort. I know in Indianapolis, the stormwater is based on, you know, how much you use versus, and so, and it may just be how your ordinance is set up too, but that's generally the kind of financial information that you would be able to get from a municipally owned utility. The information that is off limits is personal information of customers.
Yeah, it seems like it should be as accessible as everybody's taxes. You can look up mine and I can look up your real estate taxes.
It's, right.
Right,
That's what I like
it's
to do
based
too.
on square footage, so, thank you.
Yeah. No, I'm good.
Oh, okay. Well, that brings up a point that I think we always like to emphasize especially to the public officials in the room. A public agency is not required to keep all public records forever. Generally, you know, there are some records that are deemed permanent records, like the official minutes of the school board, the sort of things that are historical in nature. But at the state government level, there's what we call retention schedules that are adopted by the Oversight Commission on Public Records, and actually there's an ability for local commissions on public records to adopt those schedules to assist agencies at the local level in managing their records. If you don't manage your records well, responding to a public records request can be a nightmare. If you have everything for the last 50 or 60 years and someone asks for it, even though you don't have to keep it, but you have it, then you're going to have to go to that dusty, dirty warehouse and get those boxes and produce them. So it's important for public agencies to manage their records not only for their daily business, but also in responding to public records requests. Now, there's going to be times where people request records that you have destroyed in accordance with the law. That is an appropriate response to the request. If they ask for something from 10 years ago that you only had to maintain and keep for 5 years, then you say that record no longer exists. And, there are times where someone will say, well, you can't get rid of a record. That's, this is the public record. You can't destroy it. Yes, you can. There is, under Indiana Code 5-15, which is the records management law, local and state agencies have the ability to dispose of public records and or send them for archiving. A lot of times, if they have a historical or legal significance beyond sort of the regular business period, they are kept in your county archives or at the state level, state archives. Andrew actually recently wrote an opinion where there's sort of a connection between the Public Records Act and the Records Retention Law. Because under the Public Records Act, you are obligated to comply with records management law. If you have destroyed a record that shouldn't have been destroyed, it is a violation of the Access to Public Records Act not to have that record when someone makes the request. So local public agencies in particular need to be concerned about this because there is a criminal provision. It's not a felony, is it? It's a misdemeanor? Do you remember? Misdemeanor. But at the local level, if a local official has destroyed a record in violation of this records management law, they could face criminal penalties. There is not a similar provision for state government. We don't know why. So it's been that way. But that's something to keep in mind. It's good, records management laws are there to help agencies to do their job, not get inundated in paper, although everybody told us we'd go paperless. How long ago? 20 years ago? We haven't done it. But those are the kind of things to keep in mind is if you keep your records manageable, when you get these requests, sometimes the overwhelming feeling you get when you get that request and you've got boxes and boxes that someone may have to go retrieve or go through. Just make sure that you're complying with records management. At the county level, the county clerk typically serves as sort of the center point for the county commission, but it's also county clerk, the circuit court judge, the superintendent of the largest school corporation. So it represents a lot of the units of local government. But check if you're one of the people from an agency that hasn't done so, please check with your county clerk and see where you might be able to go, because you can make requests to actually destroy certain categories of records after so much time, and you just need their permission before you can do it.
The records we're talking about are records concerning the business of the government agency. So if you're a public official and you send an email on your government account to somebody else and saying, hey, would you like to go to lunch at 4 o'clock or at noon today, that's a record, a public record, but it's not a record concerning public business. So once they receive a reply, if you delete it, that's not a problem. My favorite story on retention and whether or not you could retain or not, there was I believe it was a city council recently that as part of their openness, they were videotaping and streaming on the internet their meetings, which is a great thing. What happened to them, though, is that the meeting ended and someone forgot to hit the button that stopped to stop recording the event. A reporter came up, started talking to one of the council members, and this is all meanwhile still being recorded and apparently still being streamed on the internet at the time. And they were picking up the conversation, and the council member and reporter started talking about the other council members and how good a job they were doing or not. So this all got recorded, and at the time, if somebody realized it immediately there, they could have went back and erased the version after the meeting ended, because what was going on in this conversation wasn't part of the public business. This was just a conversation. but somebody had saw what had happened on the internet and made a records request. Well, at that point, they couldn't go back and erase it because it was a public record and there was a records request for it. So it was embarrassing, I think, not only for the council member, but also the reporters. They were giving their opinions on the different council members. So retention is an important aspect, and it does need to be taken seriously.
I have a question.
Okay.
Oh, I'm sorry.
If a local agency passes on the records, you know, they no longer need to retain them by law, but they pass it on to an archives or a library, does the local agency then, if they get a records request, have to go to the archives or the library and retain those or, retrieve them?
No, that's a good question. Once the local agency has complied with the management laws and sent them on to the library or to historical society or whoever is designated by the county commission, the local agency no longer has title to that record. I mean, you're not going to keep a copy. Now, if you kept a copy, I'd say yes. If you have it in your possession, in a lot of cases, you're going to be sending the originals, the things, and if they're old enough records, minutes from 20 years ago, that sort of thing, you may not have a business purpose for even keeping a copy. You know, you can always go over to the library or to the historical site if you really need to get it. Or you may scan them before they go. In that case, you've now made a copy. So it depends. If you have a copy, if you've kept a copy, I would say yes, you need to produce that like you would any other record, the original. But if you haven't kept a copy, you can direct them to the other agency.
The flip side to that is like if there are two agencies that have the same record and they come to you asking for a copy of the record, you can't push them off on the other agency. Says, well, we're busy. Why don't you go over to such and such an agency and let them get the record for you? So if you've got the record, you need to comply with the request.
Right.
See another question?
Yes, with the development of scanning software, can records be scanned and maintained in that format and then the paper copy destroyed?
That's a good question. It's with scanning technology, can you scan a record, keep it in that form only, and get rid of the paper copy? That would be up to, right now, only the state level, State Commission on Public Records has authority to adopt retention schedules, and some of those you'll see that they will allow agencies that have high volumes of documents to burn them onto a disk, used to be microfilm, so that they can have them available, but then sooner than when they would actually destroy the original. And that would be on a case-by-case basis. They'd look at whether or not there was a reason to keep that paper longer, the original. Courts are accepting facsimiles more now, so I think it's a little easier and as long as you complied with your retention schedule. At the county level, I'm not sure whether they're doing that unless the county has adopted a retention schedule that the state has permitted them to. But yes, that could be an option, but you'd have to get the clearance from the Commission on Public Records before you would do that.
The problem with that, the Public Access Counselor sits statutorily on that state committee. It's surprising to me, I didn't really realize that until I got into this, but that electronic storage is not as permanent as you may think it is. Hard drives, well, every time you copy a file electronically, it gets corrupted, so there's instability there. And then the hard drives themselves break down after a certain number of years. CD-ROMs and DVDs are not reliable permanently either. So as far as I have heard, people who know this better than I do have told me, microfilming is still the best and most dependable way to store records permanently, which is not convenient for anybody right now. But so like Ann said, there are certain classes that right now you can store electronically, but permanent storage is probably going to require either storing that paper permanently or microfilming and storing that.
And sometimes there's a backup microfilming as well, because they keep those separate so that if there's a fire or water damage.
Yes, would verbal permission by previous administrations be deemed a less disclosable item to the public? And my example is, there's been flooding and there's been emergency diking put up. Would verbal permission just do it to prevent flooding? But then, we have problems down the road with, dikes that are still standing that aren't doing what they're supposed to be doing. Just things like that I'm curious about, where verbal permission was given in emergency situations, and how disclosable that is to the public, as far as, you know, records.
Well, the problem is with the verbal, there is no record. If I tell you, yeah, go ahead and do something, there's nothing that anybody can come back later and say, can I see the document that gave permission for that? So unless there's some sort of follow-up records created, that there's no record that you can request. You know, it's like a telephone conversation, you know, only the two people involved in the conversation know what was said, and anybody else is kind of, you know, dependent upon what their memory is. So what you got is a no-record situation, even though there may have been action taken, official action taken, but if it was all done verbally or based on a verbal permission, there is no record that you can refer to later to say why this happened.
How is the public supposed to perceive that, though, as something being done, you know, possibly illegally? You know, you just can't do that kind of stuff without having studies done, environmental impact studies done on, you know, existing properties around. I mean, you know, you're dealing with a lot of different things that could
If you're talking about things that were done that weren't following the statute as far as studies and things like those, I mean, what you have there is that you can ask for the record saying, the state law requires this study to be done before this work is done. I want a copy of the study that was required. And, you know, if they don't have the study, now you've got evidence of whether it could be a problem as far as whether the law was passed. And then you may be going to whatever entity is in charge of enforcing that statute to say, we have a problem, you know, they've done this work, they can't produce a record that shows that they did step A and B that they were required to do before they did the work. And then that may prompt an investigation, whether it's by the Corps of Engineers in the case of dikes or something, or it could be, if it's financial, it might be the State Board of Accounts. So, you know, that's part of the reason why the records are available, so that you are able to go in and be able to verify that things were done correctly according to a lawful process. So the fact that they don't have a record they're required to have may be evidence that goes against that agency and their action.
Thank you.
Well, I'm going to talk about a topic that is near and dear to Steve's heart, board packets. And many boards and commissions use board packets for their members to get them knowledgeable prior to a meeting. And as a general rule, once that packet's created, it's a disclosable public record. Now, as I mentioned earlier, sometimes written documents may have a mixture of confidential information, or there may be a memo that is intended for decision-making. It is the public agency's burden to mark those appropriately. If I'm a member of the public and say I'd like a copy of, or I'd like to see the board packet prior to Thursday's meeting, then that information needs to be removed, and you need to alert the person that confidential information or information that's been appropriately not disclosed under one of the discretionary exceptions has been pulled. This gets difficult because a lot of times the people putting together the packets are just given documents saying, get this together for the board members. And many times people believe that if the board hasn't seen it yet, like let's say it's in transit to them, whether electronically or by mail or courier, that the public can't see it until we know the board's seen it. That's not how the law works. Once you've created a packet, you just need to be careful that anything that you're communicating that would be, the content of it would not be disclosable, that you do not disclose it to anyone but the board members. The board members obviously are the governing body for the agency, so it is, there may be information that's communicated to them appropriately through that board packet. My advice is always, if you're going to have something like that you're going to be sharing with the public at some point, communicate the discretionarily disclosable and the confidential information separately. Because sometimes your board members, if it's not marked appropriately, they don't know. And someone comes up at the meeting and says, can I see your packet? I didn't get a chance to request one before this meeting. Hand it over, and within that packet is something that shouldn't have been disclosed. And in the case of confidential information, it could be a problem because releasing confidential information has criminal penalties. Using electronic, a lot of boards and commissions now use their websites to post these things, which is great because that means you as the person who might have to give out copies knows you don't have to make as many copies. Many people will be happy to look on something online. You just need to notify someone. But if they still want a paper copy, it's just like any other document in your office, you'd have to provide it.
In application of that, of an actual board meeting in process that does not use a hard copy packet, but uses a closed system network of computerization. So they have a screen in front of them that the board members alone see. No one else sees. Is that considered a packet? Or is that something other?
I don't know if I would call it a packet, because usually we talk about board packets, and something's given to the board in advance so they can kind of prepare. Sounds like in your explanation, it's something that they maybe, during the meeting, they say, okay, if you will call up, your item. So it may depend on how it's given, whether or not it's a board packet or if it's just a document that they're retrieving at that very instant. But in either case, it's probably going to be a record that's publicly available. The problem from a system standpoint is the way they've got set up. It doesn't sound like there's a screen, so you can see the records that they are looking at. So you'd have to either hope that you could get part of that board packet ahead of time if they know what they're going to show them, and they could access or give you access to those documents, or you're going to have to follow up after the meeting and go and say, I know during the meeting they were looking at this document, I'd like a copy of that document. Doesn't sound like it's necessarily a system that's friendly to the people in the audience, the way they've got it set up. But that doesn't mean that those records still aren't records that you should have a right to be able to see. But you may not, the way they've got it set up, if you don't know what records they are, you may not be able to make the request until after the meeting and then kind of catch up on what's being done. The board packets in general, most agencies are understanding of board packet requests, and they know that a reporter might want them to, they can do an advanced story before the meeting to let people know what the main topic is, or if they want citizens to kind of follow it, whether it's the PTA or whatever, they understand why they want to know this information so they can follow along better. But there are occasional entities, and unless it's changed, I know one of the Fort Wayne School District has been just fighting tooth and nail over these board package requests, and I don't know what the motivation is on that fighting it. I don't know if it's a case where they don't want the newspaper to do an advanced story because more people might come to the meeting and give them their opinion, and they don't want to hear the public's opinion, or if it's a case where you have a superintendent who maybe want to kind of control the message to the board and making sure that he gets to explain and explain to them what's in the packet before a reporter contacts and starts raising questions. So, but I know that there is a particular, unless it's changed, one school district up there who has been fighting tooth and nail over allowing anybody to see into the records, in these board packets. And from a citizen standpoint or whatever, I'd be questioning why, what's the motivation not wanting to share the information.
Common knowledge packets are done on Thursday, but they won't give any information out. What's a reasonable amount of time if the meeting's on Monday, the packet is done on Thursday, if you expect them to turn that record over?
If I was asked, if the records are there in hand, or if they even know that if they know that somebody wants them, the easiest thing is when they're making 7 copies for the board, and they know that somebody else is going to want it, go ahead and make an 8th copy right there. And what's unreasonable about when you come in on Thursday or Friday after they've been done, to hand it to that person so they've got them before Monday. So I would argue in that kind of situation, reasonable ought to be pretty quickly. Now, if it's a complicated packet and they did it Thursday, they didn't know that somebody's going to make the request, now you come in on Friday and say, I'd like a board packet, well then they might be able to make some arguments about, well, gee, I need a little bit more time or whatever, and I can't give it to you until Monday or whatever. But I don't think it shouldn't be a case where if they've got it and you come in on Thursday or whatever, that you'd have to wait until after the meeting before they would release it.
And even if there were a complication with getting it all copied for you, I think you could stand there and inspect it. The law still gives you a right to inspect and receive a copy. So if it was 4 o'clock and they were closing it at 4 o'clock, say, could I take a quick look, but could I get a copy tomorrow? At least you'd have a little advance. sometimes too, I mean, the law does say that you have, an agency has to respond within a reasonable time to your request. But in a case where they only create a combination of documents on one day and 2 business days later have a meeting, it doesn't leave a whole lot of time to, for that reason, you know, production is gonna be sort of based on the fact that people are asking because there's a meeting on Monday. If you say, we'll get it to you next Wednesday, that has no validity. I mean, that just doesn't help. So the agency's got to have a pretty good reason. I dealt with this a lot when I was access counselor. They'd say, well, we just don't think that they should get it before the board members. You know, but honestly, you know, most of the information in the packet is stuff that if they knew what was going to be in there, they could ask for it and get separately. It's just, you want to know what the board's going to be acting upon so that if and when you attend, or if someone attends, they know that a topic's going to come up. But yeah, the board packets have this, I think there's, and I've dealt with a lot of boards and commissions as an attorney, and sometimes there is sometimes a, when you are working for a board or commission, they have this, someone may have the impression that the board would be upset if someone else saw it. You know, in a case like that, I think it may even help to talk to the presiding officer, you know, after one of the meetings and say, look, you know, this is all, you know, I'm getting a little grief about getting the board packet. And you just sort of on a professional level say, it's not a matter of, I'm trying to, you know, I'm just trying to see what you guys are going to act upon at your meeting 3 days later, and I'm sure it's because the staff feels like they shouldn't be giving it to me when it's ready. And see where that goes. Sometimes just a little bit of, you know, trying to combat it without getting anybody in trouble, to say, look, is there a way that I can also see this packet on Thursday or Friday prior to this meeting on Monday, because otherwise I'm not going to be prepared. You know, I'm writing a story, or I'm a person I'm the PTA president, and I've got to know what you're acting upon so I can, you know, be prepared to answer questions. If I don't know, I'm going to necessarily, you know, not necessarily show up with the right information. So.
Yes.
You said there are criminal penalties for releasing confidential information. What are the criminal penalties for not releasing public information?
There are no. That's a trick question.
Not high.
That,
Yeah, for better or worse, there are no criminal penalties.
So what recourse does a citizen have when public records are denied? What can a poor citizen or a newspaper or any other media organization do when that happens?
Well, it's interesting that you asked what a poor citizen can do. Is that deliberate? As opposed to a rich citizen, we have probably many more options. Well, typically the first stage in that kind of a process would be to call my office and then file a formal complaint. As a practical matter, that usually solves most problems. I found that there are only a very select few of agencies that will belligerently say, look, public access counselor told us we need to release this, we don't care, we're going to hang on to it and you can take us to court. But that is the next step. If we've issued an opinion saying it should come out and the agency disagrees, they want to keep it confidential, then the only recourse at that point really is to go to, well, I should say the unofficial action at that point is to call you or your colleagues in the media and say, hey, can you help me put some public pressure on this agency? Here's what they're doing. Often that will get the job done, and if there's a public access counselor opinion out there, they can say, look, there was this official opinion saying it should be released. They're still saying no.
How long typically does it take your office to respond to a formal complaint?
30 days max. That's a statutory deadline. So.
I kind of liken it, not that I'm saying that public officials are children, but it's kind of like dealing with the child. If the child starts walking towards the electric plug, first off you say, don't do that, and if they keep insisting, then you may have to slap their hand or pull them away or put it in the corner. A lot of times the violations may not necessarily be malicious, but either it's because they're panicked or whatever. So, I usually, you suggest you start off talking to the agency, trying to explain to them, why you disagree with their ruling or not giving the record. then you may have to go to a public access counselor, or you may have to go to, if you're a citizen, you may want to involve your local newspaper to try to get their, help them bring public policy. The final recourse is, if you've gone to the public access counselor who's ruled in your favor, or even if they haven't ruled in your favor, but you think the public access counselor is wrong, is to take the entity to court. Now, if you've gone to the public access counselor and then gone to court, if you succeed, the judge will be required to tell the public agency that they have to reimburse you for reasonable attorney fees and court costs. Now, depending on your arrangement with the attorney, that may you may have to spend some money up front and then get reimbursed. And frankly, the thing that distresses our association is that even in that scenario, when you force a citizen to take someone to court and they win, who pays for that? It's the other taxpayers, because if the public agency is required to reimburse the citizen for their attorney fees and court costs, that's coming out of their taxpayer-paid budget. So if it's a case where you have the bad actor, and there are a few, I mean most public officials want to do what's right, but there are a few bad actors. But as it stands now, for the bad actor, if they don't care about the bad publicity and they don't want to give that record, they can basically call the bluff on the citizen and say, if you want this record, sue me. And if the citizen does sue them, even if they lose, they bought another few months before they have to give the record up, and they don't have to pay for the attorney fees and court costs. It's coming out of their agency budget. So, frankly, we have been seeking from the legislature the ability for a judge who finds that it's a deliberate violation, not a matter of law and whether or not a record should be available, but if it was a deliberate violation of the law, then that public official, we feel, ought to be able to hit by judges with a civil fine. Now, there are 31 other states that either allow for civil fines for deliberate violations, criminal penalties, removal of office. So, what we're asking for in Indiana is not anything radical considering the public's access. But at this point, we haven't successfully got through the legislation or through the General Assembly, but we'll be making another push this next session. So, again, all we're looking for is enforcement that touches the bad actor in the situation. Well, I guess they don't like that idea.
Timers.
But we don't have that right now. So the citizens do have to enforce it. You can't go to the AG, you can't go to the police, you can't go to the prosecutor and tell them they're not giving me the record I should get. It's a citizen-based enforcement process right now.
I think the next hot topic is, and this is a hot topic, is the issue of personal email accounts and public email accounts. Right now in Indiana, there's a fairly bright line rule between those two types of records, where if you have a public, for example, my email address that's on the back of the program, the handbook, that all goes into the state's server, and it's public record just like anything that's mailed or faxed to our office. Then I have my own personal email account that I talk to my wife to and anybody else. So if someone submits a request for both of those, like I said, there's a fairly bright line rule that the public emails are public record. The personal email account at this point is not subject to the Public Records Act. But it's getting more complicated. And what I'm trying to advise public officials to be wary of is that, that's the current rule, which could always change. Or you could get a judge who decides that the Public Records Act should extend to personal emails under certain circumstances. Maybe if you're sending it from a public computer, your office computer, maybe if it's a personal email account, but you're conducting public business through that. Or what I see a lot of is, especially at the local level, where some officials don't even have a public email account through whatever position they hold. They'll just use their personal email to conduct all business, or they'll have something like, Marion County counselor@gmail. So it looks like kind of a public email account, even though it's through what's normally a personal email account. And then the other thing that was kind of interesting was just in the last week, you had, I don't know if anybody saw this story, but there was a hack into the White House, a lot of the White House staffers' personal emails. It was a Gmail hack from China, and all these accounts were exposed, and of course they came out and said, well, we don't conduct public business through our personal email accounts, that's because there's a federal statute that requires them to do that through their public accounts, but at the same time they're very panicked about what was going to be exposed. So, you know, there are security concerns as well that I think aren't as reliable on the personal email side. So just some things to kind of be aware of. You know, the best course of action is just to use your public account for public business and keep your personal emails separate, and I think you'll be in pretty good shape.
Well, I don't know how much you've been following, but there are some examples where email, will definitely get people in trouble. There's a situation involving the Indiana Utility Regulatory Commission where an attorney who was part of, there's an attorney part of the Indiana Utility Regulatory Commission who appears by the emails was getting cozy with one of the power companies that he was dealing with as an administrative law judge, and the emails were public records, and the Indianapolis Star were able to make requests, and they were turned over, and some very incriminating language in there when they talk about how they could hardly keep a straight face before the Ethics Commission. So if you're a public official, don't think an email is something you send and it disappears. Go by what your mother always says. Don't put something in writing that you're not afraid to have on the front page of the paper.
Did your mother really say that to you?
Maybe not. We didn't have email when I was a kid, but she would have. She would have said that.
Okay. One subject matter I mentioned earlier that has a lot of discussion because it's one of those exceptions that is written in a way that oftentimes people say, well, it just fit under this exception, right? And if you all have a booklet, but it's on page 33, I just want to point out to you, it's getting darker every moment here. But on page 33 on the left-hand column, about halfway down is a subsection 6. And this is the exception that I mentioned earlier, is the deliberative material exception. That's crystal clear, right? But I think it's important when looking at this exception, this is one of those discretionarily disclosable categories of records. So it says the beginning of this section says a public agency may or may not disclose the following types of information, one of which is deliberative material. And it's, like I said, it's easiest to understand, I think, by breaking it down into parts. First, it's defined as records that are intra-agency or interagency, okay, that are advisory or deliberative material, including material developed by a private contractor under a contract with the public agency, that are expressions of opinion or are of a speculative nature, and that are communicated for the purposes of decision-making. All of those qualities have to be present in order for the information you're attempting to withhold to be withheld. Oftentimes you'll see information blacked out in a memo. In a situation like that, a public agency is required to disclose part of the memo that is disclosable and redact or remove information. And the easiest way we do that with paper documents is we use the old black marker on it. You're still under an obligation, as I mentioned earlier, to state under what statute, as a public agency, state under which statute you are withholding the information. And as again, the burden is on the public agency to really be able to support that redaction if they're challenged on it. And a court would look at whether or not that was an arbitrary or capricious, exercise of their discretion. That's typical standard. And this is one that I think because it has sort of so what's deliberative? I think on the federal level they have something called the executive privilege, which is similar but not exactly the same, that a lot of times is relied upon. This obviously protects communication within an agency or between two agencies on a matter that's up for some sort of determination. And certainly when a staff member is asked to communicate their opinions, their recommendation, their speculation on a certain matter, an agency has the ability to withhold that. But anything that's factual in that memo needs to be communicated to the person who's made the request. Say, if I want the memo between, any memos or documents relating to this subject, if there's a memo that has deliberative information and material in it, it's very unusual that an entire document would be deliberative. It'd be up to the agency to prove it, but that's when you typically would see a document that's partially redacted.
When you're playing the shell game with an agency, and the agency is responding to your request for information, and they respond that we don't have that information, it's with our private contractors who hire. I get that all the time. Most of the time when you're asking for documents on a construction site, you'll ask the agency for the documents submitted from the construction site to the agency, and they'll respond back, well, the architect has that information, or the general contractor has that information, but we don't have that. And by law, the agency is required to hire an architect.
Sure.
So, in my opinion, that's an extension of the agency because they're required by law. But how do you get around that shell game? Can you make a public information request a year out? Because they say we won't have that until the project's over.
You mean if the agency has it by then, or you're in advance? You mean after the information? Well, obviously, once they've received it. But the General Assembly did put in definitions of public agency to address the situation you're talking about. It's section 2.1, it's on page 29. It basically says, in a situation where you've hired an outside contractor, this is sort of a test of whether or not the records that contractor has qualify as public records. In a case of a construction project, it is not a, that does happen a lot. They'll say, the plans are with the architect. We haven't even received them yet. Once they receive them, even in draft form, unless there's some exception, there are some exceptions for security type information or for Homeland Security if you're building, a jail, for example. There may be information they can't disclose. It's the same rules apply. The public agency needs to receive it, but yes, we have agencies that have actually tried to say, we'll just keep it with our counsel and no one will ever get it. Well, that would never meet the test of not being the public agency's information. So it is a difficult situation because there are times where the public agency says, we just don't have it yet. But once they receive it, they have to apply all the same rules we talked about with any other public record. And if there is no reason why they've received it other than they know you want it, that's where some of these other, all the public access
So I'll be
counselors.
receiving these records anytime soon now, because I asked for them in 2003.
Oh, wow.
So I'll get them anytime now?
Well, again, I think there are a couple of key points. Part of it is, does the record ever become a public record? For example, agency hires a consultant, say, we want to report on X. And the consultant does a report on X, but there's also other material that they put together as they were creating their study. They give the public agency the study, and that's a public record and should be available. But some of the things that they use to build that study may be proprietary, or they don't. It doesn't cross the threshold to become a public record. So I'm not sure exactly on some of the records you're looking for if they're records of the architect that go towards more of their own records, private records, as opposed to records they're having to create for the public agency. So there's that question. But if they are records that once they pass the threshold of being a public record, it doesn't matter who's got a hold of them. There was a specific case, Knightstown Banner versus the town of Knightstown, where the town board had to approve a settlement in a court case, but after they agreed to it, they didn't keep the copy of it. The copy was kept with the attorney, and so they were trying to say, we don't have to give it to the newspaper because we don't have a copy of it. And the court said, no, you can't hide records with a vendor or contracted entity that are public records, and this was obviously a record that they approved, so it was a public record. So it's hard to give you a specific answer on yours because I don't know if the records have kind of passed that threshold to become public records where you should be able to get them, or whether or not they've kind of maintained under the private record, which wouldn't fall under the scope. So it's hard to give you a specific answer, not knowing exactly how the arrangement is and what records they're required to provide to the state and what may not be, may just be their own, you know, like their payroll records, things on those lines that wouldn't necessarily have to become a public record.
Well, just a follow-up question, when you have three different entities that you're asking for public record, one would be the county, the city, and the chamber, to make up economic development commissions. When you request information from them, you receive nothing.
Well, the chamber would not be, chamber's not a public agency, so that they would, I can understand why you wouldn't be able to necessarily get their records unless they're tied in another way. City and the county, I mean, what I tell reporters is if you know that the records are kept by two agencies, ask them both, because you may get it faster from one than the other. So you can make the same records request for both agencies, and again, the burden is on them. If they don't want to give you a record, they